Thank you all for joining our AmTrust webinar today series. It's sponsored by AmTrust Title and Stephen Napolitano, Senior Executive Vice President of AmTrust Title. I'm joined today by Kevin Shepard of Venable, who is a practicing real estate lawyer based in Baltimore, but practices all over the country. And he also has a special interest in as a recognized expert in the area of anti-money laundering. And also joining me are Andrew Weiner from Pillsbury Winthrop Shaw Pittman, based in New York, who is a sort of a large global practice representing a lot of international companies that are going to be confronted with this regulation as well. Oddly enough, the United States for many years has been considered to be a pariah in the area of creation of entities because we probably are the largest developed economy in the world with no insight or disclosure of who the beneficial ownership of companies is. That was changed really after a lot of push and go for the last 20 years when Congress passed the National Defense Authorization Act, which contained the Corporate Transparency Act, which our speakers will be addressing. That was on, I believe, on January 1st or in 2020, the president at the time, President Trump, vetoed the bill, but it was overwhelmingly reinstated and became legislation in January of 2021. This is a statute that is really going to develop, and we're going to talk about how it's going to develop and what the risks are. And one of the things that lawyers have to remember as to customers and members is that this is a situation where there are criminal as well as civil penalties. Well, I'm going to let you, who's starting? Kevin, you're going to take it, or Andrew?
I'm starting.
Thank you.
Here we go. Thank you, Joe. Thank you, AmTrust. Thank you, everyone, for attending, and thank you, Kevin Shepard, for joining me as a co-host. We're talking today about the Corporate Transparency Act, which, as Joe said, was enacted by Congress over presidential veto on January 1, 2021 as part of the National Defense Authorization Act of 2021, as part of, actually as the tip of the tail of the Defense Department funding dog. It got very little public discussion while it was in this part of generation. And it arrived in January, and most people were unaware it was coming, and many people are still unaware of what has come. This presentation is intended to assist. It represents the most dramatic increase in required disclosure by business entities of their ownership and control in over 20 years since 9/11. It's part of a much larger web of anti-money laundering provisions in the Act, but we're only today covering the CTA. It should be understood that its provisions are not yet in effect and will phase in over several years, and we'll talk about that. It is also only a skeleton. It's to be fleshed out in regulations prescribed to be issued by Treasury within a year from enactment. Nonetheless, the CTA deserves immediate attention and may require some immediate action by concerned parties. I know that I've already started putting CTA provisions in contracts, in joint venture agreements and loan documents, and have started talking to clients about whether they're exempt, whether they're not exempt, and what they should be doing between now and when the statute becomes effective. And we'll talk about some of that. So what was the problem? Historically, corporations and other entities have not been subject to a robust disclosure regime as to their beneficial ownership and control. After 9/11, the potential use of shell entities and complex multi-jurisdictional ownership structures to hide money laundering and financing of terrorism became a matter of serious international concern, added to the perennial concern about tax avoidance. Although real estate was a particular target, the issue relates potentially to all commercial activity and to all entities that participate in commercial activity. In consequence, governments and intergovernmental entities have been working to tighten disclosure obligations, with the pace varying greatly among jurisdictions. Countervailing concerns as to legitimate privacy rights and regarding who should bear the burdens, costs, and liabilities of disclosure have resulted in a complex debate about how to structure a tightened disclosure regime. The result of a many-year tug of war is in the CTA. But why is it a big deal? Well, first of all, it is the first time that entities will be required to file information as to their beneficial ownership and control with the federal government. It is the first time the federal government inserts itself into the state entity formation process, presently a very simple process. The federal government, not states, will actually maintain this information in a database. This information will be available not only to the Treasury, but to other governmental agencies, state as well, tax entities, and in some instances, foreign governments. And it may be shared with them, and they may use it subject to provisions of the statute intended to maintain confidentiality and also to make sure that the people to whom it is disclosed use it only for the requisite actions. Non-compliance, as Joe said, is subject to civil and criminal fines and penalties. Millions of small businesses will be required to make federal filings now, and there are not many of them set up for this. There is no process for verifying the information filed. There is no protection against discovery of this information while it is in the hands of the entities who gather it. Compliance issues could set sponsors and investors against each other, attorneys, including in-house counsel, against their clients, management and ownership against each other. Attorneys will have to navigate new issues of legal ethics and potential liability. On top of this, state and local entities are beginning to jump on the bandwagon. New York has already begun considering legislation that would require limited liability companies who want to record a deed for certain property to put on file publicly all of their owners up to the highest individual of any kind who is in the ownership chain. And that's just in the first 2 months after the act was adopted. Whether this is a big deal to some extent will depend on what the Treasury does in the regulations. The Treasury has, you would consider, a choice between narrow regulations, very objective, that are easy to implement, that are very clear as to who should and should not comply, and regulations that are so broad that there is no leakage, but therefore so wide and subjective that it's going to be very hard to determine what actually to do. Yep.
Okay, thanks, Andy. Thanks, Joe. The CTA did not come out of nowhere. It's been grinding through Congress for about 15 or more years. And from the outset, there was a decision had to be made which path to take. There are two basic approaches to collecting and maintaining beneficial ownership disclosure information. The first is what they call the registry approach. And that's when the government, it can be state or federal, they create the registry. And that is the registry that houses the beneficial ownership information. So that's one approach. The other approach is what we call the company approach. And that's when the entity itself holds the beneficial ownership information. And when law enforcement needs that information upon a proper showing, they can contact someone at the company to find out that information. Law enforcement doesn't like that, or did not like that approach, because of what they call the tipping off concern. Because once law enforcement contacts a company official, company contact person to inquire about the beneficial ownership, that will probably tip off the company that law enforcement has an interest in that entity. Law enforcement doesn't want that to happen. So that brings us back to the registry approach. You file this information with the government, and certain individuals can access that information, and the company will never know about it. So that law enforcement likes that approach. In terms of the impetus to enact the CTA, there are a couple of things to keep in mind. One is it wasn't only just the domestic pressure, it was also international pressure. And it's important to understand what the international dynamic is. There was a group called the Financial Action Task Force, FATF, which is housed within the OECD in Paris. And that's an international intergovernmental agency that sets the global standards for anti-money laundering and counter-terrorist financing. And they're called the FATF standards or FATF recommendations. The US is a charter member. There are over 200 countries that subscribe to the FATF standards. And the US, in fact, held the presidency of FATF in 2018, 2019. The FATF standards or recommendations have undergone changes over the years, but there are basically 40 of them. The one that is of most interest for this discussion, and the one that has created most consternation, both domestically and globally, deals with FATF Recommendation 24. And it's worth reading it in whole because this is, I think, drove the enactment of this legislation at the end of the day. It said countries should ensure that there is adequate, accurate, and timely information on the beneficial ownership and control of legal persons, and this is important, that can be obtained or accessed in a timely fashion by competent authorities. Competent authorities is just a code word for law enforcement. There's been a lot of pressure exerted by FATF for all countries to comply with Recommendation 24, including the US. Well, how does FATF do that? FATF doesn't, it's not Congress, it can't enact laws. It operates by the ultimate peer pressure system. And some have referred to FATF as probably the most powerful entity in the globe, around the globe, that the fewest people have heard about. It basically sets the standards for trillions of dollars in the global economy. But they do it through a peer pressure system. They conduct mutual evaluations of other countries on a periodic basis. About every few years they do that. The US had a mutual evaluation conducted in 2006, 2016, and they had an updated of the 2016 evaluation in 2020. The US did not fare very well. It got a non-compliant rating, the dreaded NC rating, for compliance with Recommendation 24. We're in good company with China and Uganda and other countries, but I don't want to highlight that too much because a lot of other countries also can't comply or unable to comply with Recommendation 24. There are countries with partial compliance, a PC rating, but there are very few with fully compliant ratings. So the US has received an F every step of the way on Recommendation 24, and that's been a significant source of consternation with Congress and US Treasury over the years. Let's turn to the domestic pressure. So we talked about the international pressure point. What about on the domestic side? What's been going on there? This legislation is not new. The CTA, the genesis has been around, like I said, for 15 plus years. There have been a number of bills introduced before the US Senate and the House of Representatives to address it. In fact, going back to 2008, Senator Carl Levin and then Senator Barack Obama introduced a bill, and it did two things. One, it would create a database at the state level, not the federal level, but the state level. And that immediately got the attention and opposition from the National Association of Secretaries of State and others. And the other thing too, I was curious about this bill, the attorneys would be characterized as formation agents, and they would be characterized as a financial institution under the Bank Secrecy Act. And that would bring along with it, within its sweep, AML compliance obligations. That legislation never made it out of committee. I testified before the US Senate on that particular legislation with Levin presiding. Then in 2010, there was another bill sponsored by Representatives Maloney and Frank. That didn't go anywhere either. But in 2019, the logjam started to break. That's when there was a bill by Representatives Maloney and King, and it was called, just concurrently with this bill, the Corporate Transparency Act of 2019. That's the first CTA type bill that made it out of committee. And in fact, it passed the House in late 2019. And that was a significant situation when that happened. There have been other recent beneficial ownership disclosure bills, and the CTA includes elements of these bills. And just a couple of them I want to point out. If you look at the curious titles they have, one is called the Title Act, and one is called the Illicit Cash Act. and they've been sponsored by various senators across the whole range of Republicans and Democrats, but they haven't gone anywhere. But again, some features of those bills found their way into the Corporate Transparency Act. Which brings us to what Joe mentioned was the National Defense Authorization Act. The Corporate Transparency Act was part of that act. It was Title 64 at the very tail end of it. And the NDAA also made very significant changes to the Bank Secrecy Act. In fact, they're the most significant ones that have been made since 9/11 and the USA Patriot Act. Congress passed the NDAA in December of 2020. Then President Trump vetoed it right before Christmas, but Congress overrode that veto on January 1, 2021. And what's interesting about that is that that bill, the CTA, was cloaked in national security language, is attached to the National Defense Authorization Act. So I think the strategy was to make sure that CTA rode on the coattails of some legislation that was assured of passage, and the NDAA was a good vehicle for doing that. So I think what the CTA reflects is just a large degree of frustration by law enforcement to get access to beneficial ownership information. There are over 2 million entities formed each year, and Treasury, law enforcement and others have had a hard time trying to find out who actually controls this entity. And in fact, the legislation has an analogy to those Russian nesting Matryoshka dolls. You're probably familiar with those. You take out one doll, you take it apart, there's another one inside, and you take that apart, another one. And that was how law enforcement was engaging in this issue. They could never find, in many instances, who the true beneficial owner is in a particular entity. And this act was designed to address that. There was also an impetus from US Treasury. They tried to establish or to get together a body of empirical data that would lend support to the view that entities are being used for malign purposes. And one intriguing part of that was what Treasury started to issue in 2016 were geographical targeting orders, GTOs. And that required title companies to collect and report information about persons involved in certain residential, not commercial, but residential real estate transactions in certain geographic areas. Think San Francisco area, Seattle, South Florida, some boroughs in New York City, Honolulu, Chicago, Boston, and other geographic areas. And then the GTOs contain language that was similar to what ultimately was found in the CTA. But what the Financial Crimes Enforcement Network, FinCEN, that's an arm of Treasury, what they found was that the GTOs revealed a significant number of high-value residential real estate transactions had undisclosed owners of corporations and LLCs engaging in potential money laundering. And Treasury said, aha, now we have empirical data to establish why we need this legislation. There has always been a concern that Treasury would expand the GTOs to cover commercial real estate transactions, but the CTA does not address that. What's the bar been doing? The ABA enacted or adopted a resolution in 2008 that opposed the beneficial ownership disclosure reporting and the regulation of lawyers informing business entities. There's a concern that may violate the attorney-client privilege, impinge on the duty of client confidentiality. And so there's always been that opposition from the American Bar Association. The Uniform Law Commission also adopted a uniform law back in 2009, about 11 or 12 years ago, that adopted or embraced a company approach. And this bill was probably more complex than it had to be, but it was complex, but it said, look, each company has to designate a records contact person. That's who law enforcement has to go to if they need to find out who the beneficial owners are. The US Senate at the time did not like that. They poo-pooed it, and that never went anywhere either. So that's been sitting on the shelf for all that time period. Just quickly on some other policy bases for the CTA. We've all seen the stories in the New York Times about rich foreigners buying high-end co-ops with cash through LLCs. No one knows who controls those entities, where the funds are coming from. There was that 60 Minutes expose dealing with 60 Minutes contacted some New York City lawyers, and that created a problem because there was a suggestion that they were trying to facilitate money laundering or finding ways to do that. So that wasn't very productive. The Panama Papers, that was a disclosure back in 2016. Several million documents were released to the press, and that revealed nearly 250,000 entities that had been formed, largely by a Panamanian-based law firm. And that just underscored again that lawyers and others are forming these entities for illicit purposes or alleged illicit purposes. And you had the Paradise Papers on the heels of that, and most recently the FinCEN Papers on the domestic front. So this whole lack of beneficial ownership disclosure information has been perceived as a true vulnerability to the US's anti-money laundering regime, and Congress has been dead set to enact legislation to address it. The other concern too is the US is very good at telling other countries how to comply with the FATF standards, but some of those countries turn around and say, thanks for telling us, but what are you doing? You haven't done anything. In fact, you received an F for the last 15 years. So that was also a pressure point. A couple other things too. The USA Patriot Act started a process of imposing the KYC, know your customer obligations, on financial institutions, and we had the CDD rule that was rolled out in 2018 that required financial institutions to develop and implement appropriate risk-based due diligence on their customers. And what was important about that CDD rule, and I think everyone is probably familiar with it, it contains an ownership prong and a control prong. And banks have, they've complied with that particular rule, but there have been criticisms of it. The financial community wants to shift some of those responsibilities to others in this regime. And the CTA tries to address that concern by financial institutions as well. Andy, do you want to take this one from here?
Sure. So getting to the meat of the legislation, the CTA requires FinCEN, that is the Treasury, to create and operate a secure, non-public database called the Beneficial Ownership Registry. It contains information from reporting companies, we'll get to that, as to individuals who constitute their direct or indirect beneficial owners, again, a defined term. FinCEN is instructed to create and operate the registry and interface with agencies responsible for registering entities created under the laws of states, localities, and Indian tribes. And again, as I said earlier, FinCEN is allowed to share information with other governmental entities. Also, they can share entity regarding a reporting company with a financial institution if the reporting company authorizes it to do so. And you'll see those in loan agreements, I would say most loan agreements coming soon. So what's a reporting company? Who has to report? Well, first, what do they have to do? They have to file with FinCEN what's called personally identifiable information of their beneficial owners. At the time of the company's formation, that's the first filing. And periodically after that, after this regulatory phase-in period, comparable information from applicants has to be filed as well. We'll get to that. A reporting company means a corporation, LLC, or other similar entity that is created by filing a document with a state Secretary of State, or if it's formed under the laws of a foreign country and registered to do business in the US, it then has to comply with the CTA. A foreign company not registered to do business, not qualified to do business in any jurisdiction in the US is not a reporting company and does not have to file a report. But what's a similar entity? Limited partnerships? Almost certainly so. Limited liability partnerships? Almost certainly so. Statutory trusts? The question about whether trusts must comply is one of the most interesting to be dealt with in the regulations. But what foreign entities are similar? And foreign entities, as I said, are not included unless they qualify. However, they have to be disclosed as a beneficial owner, even if information as to their owners and control parties don't have to It's not something that has to be disclosed. This is a huge loophole. And those of us who are looking at the CTA just noticed it in awe. What is a reporting company? Again, there are 23 exemptions to the definition of reporting company, and these are generally classes of entities already subject to substantial regulatory regimes or that are considered relatively to present no risk or that have good lobbyists. And I'll just give you a few examples. There are a lot more than this, but these are the major ones. Banks, bank type entities. Any entity that is a US person and employs more than 20 full-time employees in the US and files income tax returns showing more than 5 million in gross receipts or sales and has an operating presence at a physical office in the US is exempt. However, it has to have filed the requisite tax return. So a newly formed entity by definition so far is not exempt, and you have to every year determine whether you qualify for the exemption. 501c3s are largely exempt. Publicly traded companies that register with the Securities Exchange Commission are generally exempt. Registered investment companies and investment advisors. As a result, pooled investment vehicles, funds, of which the ownership interests are operated or advised by some of these exempt entities, are themselves exempt, which is something the funds industry is going to be looking at very carefully. Entities that are 100% controlled by an exempt entity are generally exempt as well. 99% does not qualify. And entities which are not engaged in any material business don't have to file as reporting companies, although they may have to file in order to get the exemption. A special provision regarding government contractors we'll talk about a little bit later. So who's the beneficial owner? Who must be disclosed? A beneficial owner means, with respect to a reporting company, an individual who directly or indirectly through any contract, arrangement, understanding, relationship, or otherwise, and that's the statutory term, exercises substantial control over the entity, that's the control prong Kevin mentioned, or owns or controls not less than 25% of the ownership interests of the entity. Again, this is a disjunctive or. It's either control or ownership. This definition at its fullest literal extension is breathtakingly broad and subjective. We'll go through some of the issues it raises, but there are only some. What is substantial control? It's not really a well-used term. Arrangement, understanding, relationship, or otherwise doesn't require a writing. Can FinCEN use this kind of test to go on fishing expeditions? Not clear. If you are a 25% owner of a company but have no control rights, anyone who has control over you must be reported, it looks like. So this is a much broader web of disclosure, even than it seems at first glance. So again, about control. If decisions are made by unanimous or supermajority decision, or if decision-making is diffuse, does each voter exercise substantial control? Is an asset manager, a property manager, someone with substantial control? If you're necessary for a quorum to exist, do you qualify? In a tiered ownership structure, is the decision maker at each level a decider? Is day-to-day management substantial control? If you have major decision rights, as is true of almost all joint ventures in the real estate space anyway, does that qualify you? If you're a lender or a creditor class and have controls in your loan documents or in a bankruptcy or reorganization, what about that? And what rules of attribution exist? Are family members going to be clumped together? We don't know. And what does 25% refer to in terms of ownership? How are different classes of stock treated? How is percentage ownership determined in entities with complex capital stacks? How are tiered returns, promotes, contingent payments taken into account? Is debt-like preferred equity considered ownership? This is a phenomenal opportunity for controversy between the people who are tasked by the statute with making a report, and the people who are not the same, who are the owners or controlling parties and have to provide, in many cases, the information to the reporting person to make the reports. And if they disagree, or if there's no cooperation, what happens then? Not clear. There's some exclusions here as to who is a beneficial owner, and I'll run them through quick. It's not really clear how exactly they work, but minor children, nominees, employees, someone who only has a right of inheritance, and creditors, unless they are otherwise control parties or owners. And again, we talked about how debt might make a creditor a control party or an owner. You, Kevin.
Okay, who's an applicant? Well, that means an individual. Again, it's a warm, breathing person who is an applicant. It's not a company. It has to be an individual. One is filed an application to form a corporation or LLC or other similar entity under state or Indian tribe law. Note the word files. What does that mean? We'll touch on that a bit. Then on non-US entities, an applicant is also an individual who registers or files an application to register a corporation, LLC, or other similar entity formed under foreign law. And to do business in the US, you file the document with the state secretary of state or similar office. Think about that for a second. Does an applicant include a lawyer or paralegal who formed the entity? What about a paralegal who formed an entity 15, 20 years ago? Do you have to file the information for that person? Of what use will that information have to law enforcement today? Not sure. So that's something hopefully that will be fleshed out in the regulations. If you look at the CTA, you'll never see the word, you don't see the word lawyer or attorney anywhere in that 60+ page statute. Lawyers are not addressed in their capacity as lawyers. So there's not an exemption for lawyers or law firms. So you have to think about, does that implicate the law firm with whom an applicant may be affiliated? We need to see how the regulations treat that. The reporting obligation requires that the report filed with FinCEN identify each beneficial owner, which Andy talked about, and each applicant with respect to that reporting company. And an applicant is going to be on the hook because a lot of these newly formed entities have no owners or assets at the time when they're formed. When does the applicant or the applicant's lawyer or law firm cease to have responsibility for future filings by the entity? Andy noted the periodic filings that have to be made. There are changes in beneficial ownership. That has to be noted with FinCEN. Should you as a lawyer be the applicant under the CTA? Should law firms require some type of identification from clients because of that? Is there going to be some type of post-formation release from the reporting company as to the latter's future obligation? Don't know. And what risk do the corporate service companies run under the new rules? And again, note that the applicant has to be an individual. And from a law firm's perspective, from a risk management standpoint, should engagement letters start to address this issue? I haven't seen that yet in engagement letters, but I suspect that's going to be occurring pretty soon. Now we come to the fun part. What exactly has to be filed with FinCEN? What type of information must be reported? Well, you have to identify each beneficial owner of the applicable reporting company and each applicant with respect to that company by 4 pieces of information: full legal name, date of birth, your address, and it has to be a current residential or business street address. PO boxes won't work here. And a unique identifying number from an acceptable identification document or FinCEN identifier. Note what this does not include. It doesn't include a social security number for anyone. It does not include a copy of your driver's license or passport. It's just the number from your driver's license or passport. And if you don't have a current driver's license or passport, you can apply to FinCEN to get an identifying number from it. So the acceptable identification documents are non-expired US passports or driver's licenses. And again, if you don't have those, you can go to FinCEN. And it's unclear what the process will be to get that type of number from FinCEN. Maybe you do have to produce a photograph. It's unclear. It's important to note that you don't have to file your whole driver's license or your entire passport as part of this process. So I think that's good news.
Okay. This page simply repeats something I've already said, which is if you are exempt, your presence in the stack must be reported, but at least if you read the statute on its face, you do not have to report your beneficial owners, which again could be a large income. So now we go to the compliance deadlines, which is another major issue. First of all, existing companies don't yet have to do anything. But let's start with newly formed companies because they're the first to have to do something. After the act becomes effective, which is after the regulations are promulgated, which means probably a year from now or longer. The statute says a year, but in order for the act to become effective, the regulations have to be in final. The states may have to adopt legislation or regulations changing the way they file papers, creating entities, and Treasury has to form and create the database. The timing of this will be interesting to watch. But newly formed entities, after the effective date, as a condition to their formation, as a condition to the acceptance of papers by the states, must make filings showing their beneficial owners. And we'll see how that goes. One question that comes up is registration valid if incorrect information is filed? It looks like it will be okay. If not, you're going to end up having to have pre-clearance procedures, particularly for things like mergers where timing is really important. But we're going to see about that. So that's entities formed from and after the effective date. For entities that exist as of the effective date, they have 2 years after that date, which is virtually 3 years from now, to make their first filing, unless Treasury changes the rules, which it is authorized to do. And at that point, they would have to list all of their beneficial owners and provide the requisite information. And again, once you make your initial filing, you have to regularly report the changes. And the question is, how material must the changes be? Maybe it's any change. And how do you create within an entity the obligation on the part of your members to tell you if something has changed? Again, that's something I've been putting in LLC agreements and other formation documents, but that's something people are going to have to look at for every existing non-exempt entity. The retention and disclosure of this information by FinCEN. FinCEN maintains them for not fewer than 5 years after the date the reporting company terminates. So this is a long-term thing. The information is confidential and can't be disclosed, can't be used except for the prescribed purposes, and can't be disclosed except to authorized disclosees. This comprises about 1/3 of the entire CTA and would need an awful long time for us to explain. So I'm going to stop on that and keep going. FinCEN, again, may disclose this information upon receipt of a request made by a financial institution. We talked about that. Treasury must establish by regulation appropriate protocols to protect security and confidentiality. But as we know from the Russian hack last year, there is a question about whether any protection will be adequate. And the whole issue about the security of this information is going to be very interesting to watch. The next thing, which is on page 33, is one of the most important things that's going to happen over the next year. The current CDD disclosure rules are wildly inconsistent with the Corporate Transparency Act. It is acknowledged, and the statute says that the existing rules are to be conformed to the CTA over the next year. This is likely because people think that one of the purposes of the CTA is to move responsibility, as Kevin said, from the financial institutions. This is likely to make the financial institutions have a safe harbor if they rely on filed information from the reporting companies, but we really don't know yet. And it is virtually certain that every borrower will have to sign on to waive its, to consent to use of this disclosure from its lenders as a condition to the loans. Last thing before I switch over to Kevin is what we talked about, referred to a little earlier. There is a special provision in the Act relating to federal contractors and subcontractors. And it is not clear to me anyway whether this is subject to the exemptions that we mentioned earlier. In its broadest form, any contractor or subcontractor subject to the reporting requirements of the Federal Acquisition Regulation must disclose its beneficial ownership information, including its ultimate beneficial ownership, prior to issuance of the contract award. This kicks in 2 years after the effective date of the CTA, but it is something that I know the government contract lawyers in my firm are pouring through, trying to make sure they understand its implications. Kevin.
All right, let's talk about the notification of reporting obligations. This is what I refer to as the educational provision in the CTA. These provisions will be unknown to most people throughout the US. I think it's fair to say that. There are two buckets of educational provisions, one at the federal level and one at the state level. At the federal level, the Treasury Secretary has to take reasonable steps, I don't know what that means, to provide notice to persons of what they have to do to report this information and cause the IRS and FinCEN to distribute informational materials describing what those obligations are. So you'll start seeing your mailbox information from the feds about what you're supposed to do to comply with the CTA. What about the state level? And more importantly, where are states getting the funding to provide or to do these obligations here? And there's a 2-year transition period on the state level. And it says that not later than 2 years after the effective date of the regulations, so that's basically 3 years from now, states have to periodically do a couple of things. One is notify filers. It doesn't say applicants, it says notify filers. Is there a difference there? Don't know. That includes their obligation to file and update the reports that are filed with FinCEN and provide filers with a copy of Treasury's reporting company form or some type of internet link to it. And get this, all the states have to update their websites. They have to update their forms to comply with the CTA to facilitate compliance with that. And they have to tell filers where you have to file this information with the states. You have to have a physical premises to do that. So there's a lot of obligations being imposed on states. Not clear what the funding is for that, but it'll be interesting to see how that plays out in the coming months and years. Let's talk about the civil and criminal penalties. And again, there's a two-tiered structure here, and one addresses the front end problem of reporting violations. And what Congress was concerned about, and a lot of small businesses and business owners were concerned about, was the prospect of criminalizing paperwork violations, just innocent paperwork violations. Could that constitute a felony under federal law? To address that, what the CTA does is to say that any reporting violations have to be willful. So that takes care of the innocent reporting issue. And take a look at the difference between the penalty structure for the willful reporting violations and those with the what I call the other bucket of violations dealing with unauthorized disclosure or use violations. Civil penalties are $500 a day for each day that the violation continues. There's up to a $10,000 fine, 2 years imprisonment. And a lot of questions arise from that. Will Treasury adopt some type of process where you can rely on certifications provided by others to say, I certify that X, Y, and Z are the beneficial owners, or the X, Y, and Z exercise substantial control? Don't know that, but we'll see how that plays out. And will clients try to interpose lawyers in the disclosures to obtain the attorney-client privilege? Not sure whether that's going to fly at the end of the day. And again, that's something we'll have to see of how the regulations play out. But let's focus on the unauthorized disclosure or use violations. Congress was very concerned about this body of information that's being filed with the federal government, and it may be hacked and may be disclosed inappropriately. What assurance can we give to those filing the information that there are real penalties, real teeth in the act to discourage or prevent that type of situation from occurring? And if you look at the way the penalties are structured, again, civil penalties are not more than $500 a day for each day that the violation continues. But look at the fines. It's up to $250,000 or to 5 years imprisonment or both. And there's also another hefty penalty structure if you violate some other law in the process of disclosing this information. So I think there's real teeth, or the intent was to put real teeth into willful unauthorized disclosure or use violations under the CTA. There is a safe harbor. The safe harbor says, look, you're not subject to either criminal or civil liability or penalty if you have reason to believe that any report that you submit contains inaccurate information and you voluntarily and promptly, well, the promptly is you need to do it within 90 days, you submit a report to FinCEN containing the corrected information. You know, what happens after that 90 days you discover the error? Are you back to the penalties that we saw in the preceding page? Maybe so. But what see whether there's anything that's clarified by Treasury on that in the regulatory process. Let's touch on the ethical implications of the CTA. As we talked about earlier, will a lawyer or a legal assistant be an applicant if he or she forms or incorporates a reporting company? Again, there's no exemption, specific exemption for lawyers acting as applicants. And it looks like applicants need to file that report with FinCEN containing that beneficial ownership disclosure information on the applicant. But what happens if you have a situation where you have a client who refuses to comply with the reporting obligations? Take an example. Client says, look, I'll file the report, but the client doesn't do so, and you know that. What if the attorney suspects that the information presented by the client is inaccurate or incomplete? Or how about if you disagree with how the client interprets beneficial owner or substantial control? You just have an honest disagreement about that. There's a model rule 1.2D, which says that a lawyer cannot assist a client to engage in criminal or fraudulent activity. And I think you need to be mindful of that in this type of situation where these forms are being filed with the federal government, and you as a lawyer may know that something is being done incorrectly with criminal intent. There is a recent ABA ethics opinion 491 that was issued in April of last year, and that's worth looking at. That's what a lot of people refer to as the willful blindness opinion. And it basically says a lawyer cannot close his or her eyes and just ignore something that clearly to a reasonable person would show that the lawyer's services are being used to assist or facilitate some type of criminal activity. If you think that is going on, you're supposed to inquire further with the client. And if the client refuses to change course, you either have to withdraw or not represent the client any further from that point, or you can require more information. Maybe there's something that's not clear from the outset, but I would strongly encourage you to take a look at ethics opinion 491. And as we touched on earlier, what if the lawyer formed the reporting company 15 years ago? Does that lawyer have an obligation to file the required report for an existing entity? So I think those will be some discussions that you'll have with your clients to discuss those implications. Andy, perhaps you can touch on the practical implications of the CTA.
Sure. As I said earlier, we're going to have to start looking at existing documents and also having the CTA in mind when we draft new ones, because existing documents, LLC agreements, I believe partnership agreements, if the definition of reporting company comes out as we think it will, trust documents have to be looked at. They have confidentiality clauses that will probably be violated by this. They will have no obligation, specific obligation anyway, of people to provide the kind of information that you would need to provide to disclose beneficial ownership. You also have no provision for resolving disputes If I'm representing a sponsor, there won't need to be one because the sponsor will determine what has to be provided, but I don't know that all investors will agree to that. You really have got to think about it pretty carefully. And I've been talking to people in my firm. There's no consensus on what actually should go in. There are indemnifications clearly of some kind. If someone causes a fine or penalty, clearly they should bear it. But these things are not in most documents. In loan agreements, my partners make a very persuasive case that in most instances, you don't have to mention the CTA in the sense of we have to, you borrower have to comply with us ETA, but in some cases you might, and you might feel as a lender better off if they did. But clearly, as a lender, you're going to insist that the borrowers waive any right to block information from being given to you, because particularly if, as we think, lenders going to be allowed to rely on what's been filed. If your borrower doesn't file, then maybe you still have the obligation to be decided. Indemnifications, again, how far do the indemnifications that are going to be inserted go? Is it just for the fines and penalties? What is that enough? I've heard some people say, well, maybe you should be able to throw people out or have a very major penalty. Will governing documents delineate what control means? Will it change the way control is actually exercised? Will there be a migration of people who want to invest in real estate to commingled vehicles which are exempt? Again, I haven't been able to really think that through yet, but that's a question in my mind. And then for every company that keeps sensitive information, where do you keep it? How do you protect it? How do you make sure, even though FinCEN can't disclose it, how do you make sure that you don't have to disclose it if you're subpoenaed? Again, there's nothing in the statute that says the information that has been submitted in the hands of the reporting company is protected at all. What are companies going to do? It's really interesting. Again, this to some extent depends on how Treasury approaches the regulations, whether it goes to the side of clear and objective criteria, or whether what it does is say, we don't want anything to slip between the cracks. So our regulations are going to be as broad as the statute, in which case there's going to be a lot of controversy. The whole way this relates to government contracting is something I can't even understand. I've never dealt with government contracts, but the people in your firm, in your company who deal with government contracts should be thinking about this. Law firms, I've been talking to my general counsel about what to do about this. Kevin mentioned a lot of the issues that are coming up, even with a cursory understanding of the statute. And we're going to have to figure them out. We've got 10 months to do so. There is a provision, while it's no longer as important as it used to be, the issuance of bearer shares and bearer certificates is now or will be prohibited. So there aren't really bearer shares anymore in most instances, but there could be in certificates, and people should know about that. And I think we need to think about, as lawyers, we need to think about weaponizing this. I don't mean it in the strict sense, but what's the advice? When a client comes in and asks for advice, what do we say? We don't really know yet, but there's some things we can begin to think about, even in advance of regulations. Kevin and I expect to be back when the regulations come out. We're really excited for that prospect. I'm really excited for it. But then we're going to know a whole lot more. But we already know enough to begin this kind of positioning. Clients may want us to look at their documents now to figure out what's in there currently. We're just going to have to wait. And therefore, I think it could actually be a very big deal. It is certainly going to be a deal. It is not something that people can ignore. It is not a reason to wait for the regulations before doing anything. And we'll see how it plays out. And we thank you on behalf of Kevin on behalf of myself. And we thank you, Joe, AmTrust, for being with us this afternoon and giving us this opportunity to chat. Thank you.
Thank you, Kevin. Thank you, Andrew. Just want to point out that the PowerPoint is available and has been forwarded to you already, as have Kevin and Andrew's bios. We also have sent the ABA Opinion 491, which Kevin referred to, as well as an article he wrote specifically on the question of willful blindness. I want to thank you both, and I'd like to thank everybody for attending, and look forward to seeing you again. Thank you.